to use it.
Yes. Okay. Fantastic. We are now live on Facebook.
Great.
So welcome, Corrine. We are going to discuss today some very important issues for every single person, particularly adults, and hopefully this discussion is going to help everyone to make a very important decision for their future. So, Corrine Sankey, a solicitor, trained solicitor. Corrine, would you like to tell us a little bit of your background and what you do, please?
Sure. So from the start, you mean family, that kind of thing?
Yes, please. Yes.
Yeah, sure. Well, now I have 2 children, so I'm a mum and a husband, and we've got a chocolate Labrador called Chaka.
Oh.
And I'm the youngest of 9 children. So I've got, I wonder how my parents coped when I think about it. We've got 2, and that, and that, as great as that is, of course, it's hard work. So I've got 4 brothers, 4 sisters, and I'm the baby of the family. So age means absolutely nothing to me. Our family is such a range of ages. And in fact, I don't relate to it. If people say, how old is this and how old is that, I can't relate to that at all, really. I still don't know what I want to be when I grow up. It's that kind of situation.
Well, you are privileged because at least everyone, is taking care of you, so to speak.
Yeah, I mean, there's 2 ways of looking at that, isn't there? Yeah, you could say you're spoiled as the youngest one, or meantime, you could say you never get a look in, and you have to make sure that you make your point in order to get ahead, kind of thing. There's all those aspects. But I've got to say, coming up, being brought up in a big family, all I can remember is love from the family, really. So it was a very good experience. It wasn't easy, financially, obviously, trying to keep a family, and feed a family kind of thing. So I've got to say, I'm not materialistic, but I do value the fact that you have to work hard for things, and you don't want to lose them, sort of easily or whatever. And also value the fact of what our parents passed on to us. So I want to pass things on to my children. I want a better life for my kids than I had, which is typical being a parent, isn't it? That's what we all want.
Exactly, yes. Sorry, I need to make myself more comfortable.
Yeah, get comfortable.
So,
that's where I'm at. I'm the youngest of a family of 9, and I'm married to my husband, John, and we've got 2 children. Yeah.
Wonderful. Corrine, you became a solicitor. What made you to make that choice? Because it's not an easy profession, is that?
No, it wasn't my first choice at a profession. It's funny because I was thinking, I heard John Haynes say the other day, and I think he probably said this a number of times, and he quotes the Business Harvard Review, and I can't remember exactly, so forgive me, John, but he says something like you would have 4 jobs or 4 careers, and within possibly 14 jobs or 14 roles kind of thing or whatever. And that sounds pretty incredible, really. But when you think about it, it's actually true. It's true for most people that And during this COVID situation, I think most people, if they're not already there, they realize you can't put all your eggs in one basket. And so people have got a number of strings to the bow, I think. But my first passion was teaching. I always knew I wanted to teach. Where I think it's half the battle if you know what you want to do, isn't it, really?
Yes.
So in school, that was it. I always knew I wanted to teach. And in fact, I had an unconditional offer from university, which was, really quite kind of something then. So yeah, so that was me. I started out life. I was teaching. I was a lecturer, and so that it going into the law wasn't my first choice, but I came across it, and it became as if that was my pathway in life. You know,
Wow.
I was called up for jury service. That's how it started, basically. And then my interest from that led me to becoming a magistrate. And then I decided I would go and study and do more courses to learn more about the law. And then I realized, you know, actually, this takes some dedication, because the courses I was doing were courses to qualify you to be a lawyer. And that's what I did. So I didn't do it the easy way. I was a full-time lecturer. I was on a very good salary. And I gave that all up as a leap of faith, actually, to go into the law. And I remember when you go through the various stages of your studying that you do, and you go for career interviews, and they're trying to guide you as to which route you should go on, be a barrister, be a solicitor. And I remember the guy that went in for his interview before me, and he was told, don't go into being a lawyer, don't go into being a barrister, you know, basically because of his age. And actually, he was relatively young, and they were advising him, don't. So he came out of that interview, that career interview, and he decided not to go carry on with that route. And when I went in after him, I said, do not give me the advice that you're giving him. I've come into this with my eyes open. This is a leap of faith. And I've given up an awful lot to do this. And in truth, I mean, look, education you have to pay for now, kind of thing. But then
Yes.
that wasn't the scenario. But because this was like a second career to me, if you like, yeah, I did have to fund it. And I took 6 part-time jobs on at the time to fund it. So it wasn't easy, and struggled in, sat by the coffee machine some of the times and couldn't afford to buy a coffee, you know, so I didn't do it the easy way. But I said, do not tell me. I've come in here with my eyes open and know exactly what I'm doing, you know, so don't give me the advice that you've given him. Anyway, meantime, I was the only one in my group that got a training contract. So
Wow.
I suppose it says something, doesn't it? You know. So yeah,
Absolutely.
it wasn't my first choice, but it was as if everything in my life was going that way, basically. You know, I'm glad I've done
Wonderful.
it, basically. I mean, I've worked in the different jurisdictions of law, the way you do and the way that you have to, you know. So I've done.
And which one was your favorite one?
I mean, they've all got aspects that are good, like all jobs do, basically. But I enjoy what I do now. I do enjoy it. I mean, I set this company up over 10 years ago, and I think because you get to deal with people, which I always think, you know, is a really rewarding thing. And because also it's such a kind of sensitive area. It's an area that people realize should be covered and is always put off till tomorrow. And sometimes tomorrow isn't soon enough, kind of thing. But actually, if we take the step to do something about it, you can get that peace of mind. So I always find it quite comforting when I've seen clients and it's like a weight's been taken off their shoulder and they get that peace of mind knowing kind of what they've done.
Oh,
So
could you unveil to everyone what is your area of practice now?
yeah, sure. So I cover wills, lasting powers of attorney, trusts, probate, prepaid funeral plans, court of protection, deputyship. So it's the private client area of legal services. It's the kind of taboo subject, you know, that people don't want to think about but realize that they have to get done. So yeah, I think it is a very rewarding area, really.
Corrine, if we start with the wills side of things, could you explain, please, why it is so important for people to have the will ready, prepared at the earlier stage rather than the later stage of our lives.
Sure. I was explaining to you before, Marie, wasn't I, that I've just been doing this course on LinkedIn because I'm new to LinkedIn.
Yes.
And there was a comment that came back on some of the practice things we were doing.
Mm-hmm.
And somebody commented and said about wills, oh yes, that's something that is for the elderly, you know. And I thought, well, I suppose that is one way of looking at it. And it certainly is for the elderly, but it's for the young as well as the elderly and for all ages. And really, it depends what objective you want to achieve with your will. So if we start out and, you know, let's say we don't have any assets, but we have a child, you know, and our children are our biggest assets, aren't they, you know?
Yes, they are.
So one way of putting guardianship in place for our children is through a will. And people don't think of that really, you know? So if you've got nothing, you've got children, you've got everything, okay? So yeah, so putting it in place to put guardians in place for your children is a must, definitely. So that's certainly not for the elderly. And then possibly the next stage in life then is, you know, when we buy a house, and that's really our biggest asset quite often, isn't it, that, you know, we're going to buy. So in some countries it's compulsory to have a will when you purchase a property, and I actually think that's the way we should be here, but we know that that isn't the way that it is. So yeah, to cover and protect the property and bequeath it and make sure it goes where you want it to go. Because if we don't have a will in place, then our assets are going to go through the laws of intestacy.
Right.
And that means, you know, legislation is going to dictate where our assets go to, not us, and we've worked so hard for, you know, and as I say, coming from, you know, a large family, I appreciate that, and I appreciate how hard it can be to get assets and want to pass those on, kind of thing. So it's important to protect them. So yeah, so, you know, covering property. It can be for all sorts of different reasons, you know. Objectives then may move on to retirement, to worrying about things like care fees and stuff like this. So your will can change, and even if you've got a will, which is great, it doesn't necessarily cover you for all the objectives that you have in life. So, you know, it is thought that every 3 to 5 years, review your will and just make sure, actually, is it covering the objectives of the stage of life that you're at now, you know? So yeah, all ages really.
Could you also explain, because I think not many people also understand the power of attorney, could you explain to the viewers what it is and why it should be prepared?
Sure. So lasting powers of attorney. So your will takes care of your wishes once you've died. We know that, don't we?
Yes.
Lasting powers of attorney takes care of your wishes while you're still alive. So whereas in your will, you may appoint an executor or executors to fulfill your wishes once you've died, then in your lasting powers of attorney, you would appoint an attorney or attorneys to fulfill your wishes while you're still alive. There's 2 types of lasting power of attorney. So there's health and welfare, and that covers the area of your health, care, treatment, anything like that. And then there's property and financial affairs. And that basically says what it is on the tin. It covers your property, finances, paying bills and whatever. You appoint your attorney while you've got the mental capacity to do so. You appoint your attorneys to fulfill your wishes while you're alive, basically. So, in the case of health and welfare, you're appointing your attorneys to fulfill your wishes now for the time when your mental capacity is an issue. because it only becomes effective when mental capacity is an issue. But then it's too late. You can't then say what it is your wishes are, and you can't put your attorney in legal authority to fulfill those wishes because you haven't got the mental capacity to do so. So you have to take them out now for the time when you haven't got the mental capacity to do so. That's with health and welfare. With property and financial affairs, it's the same. You've got the mental capacity, you can appoint your attorney so that they, yes, can act for you when mental capacity is an issue. But with that one, they can also act for you while you've still got the mental capacity. Look, I could say to you, it could be that you've broken your ankle and you can't get out and about. You've still got the mental capacity, but you can't get out and about, kind of thing. So legally, you've then got your attorney with the authority to be able to help paying your bills and all that kind of stuff. But I don't have to say about breaking your ankle because we're all in that kind of situation now, aren't we? We're all in, with the lockdown situation that we're in. We can't freely go out and about as we did before. So actually, at the moment, there's a particular use for lasting powers of attorney. There is delays in processing things because you take them out while you've got the mental capacity. Have them all signed up, and then they're valid for life, basically. But before they're utilised, they have to be registered at the Office of the Public Guardian. And at the moment, the Office of the Public Guardian, like everywhere, have got delays in their processing. So basically, what we're doing for our clients is we're giving them free general powers of attorney. Now, a general power of attorney is for a specific purpose and it's time bound. So say you wanted it for 6 months, for example, and it's not effective when mental capacity is an issue. So it's limited, but look, it's got a purpose at the moment. So while your lasting powers of attorney, are being processed at the Office of the Guardian, to have a general power of attorney, which is instant, can fill that gap. So it's got a usefulness. So any of our clients who are taking out lasting powers of attorney, we're giving them as a gift free, a general power of attorney to fill that gap. And also there's advanced wishes or living wills. And that basically covers the area on the health side. If anybody has their wish would be, if they had a deteriorating illness, they wouldn't want to be resuscitated, for example, their wishes on that front can then be known. And that also could act to help fill a gap, as it were, while health and welfare was being processed. But yeah, essentially, they're going to fulfill your wishes during your lifetime, and you will fulfill your wishes when you've died. I mean, some people might think, what on earth do I need a health and welfare lasting power of attorney for? I've got family. My family can just tell the medical profession, if I was at the hospital, for example, what I wanted, And the truth is that, family consent, and we think we give family consent and it's legally binding. It isn't. Medical profession can overrule that family consent. And probably in reality, 99% of the time they do. Medical profession, we know, are absolutely fantastic. But if we have a set wish about the way we want our health and our care and our treatment to be fulfilled, the only legal way, and it's such a weighty legal document, the only legal way to do that is via lasting power of attorney. I suppose as an example, to put it into context, looking at some kind of previous case law, there was an example where there was an elderly couple and the wife had already been diagnosed with dementia, but the husband was never ever going to put her in a home. He was always going to look after her. But then, as things do happen, inevitably, he got taken ill at some point and he got taken into hospital. So while he was in hospital, his wife got taken into a local authority care home. Anyway, he does get better. He comes out and he wants to bring his wife out of the care home to him. And the care home refused to release her. And they said, no, they wouldn't. It wasn't in her best interest. And he said, look, some time ago, I booked a cruise for us. and the cruise is coming up and I want my wife out so we can go on this cruise. And they said, no, she's got dementia. She'd fall off the side of the boat, basically. You know, it's not in the best interest to release her, and they wouldn't release her. So he took it to court and he lost the case. So he took it to appeal. Now, the appeal case was on the Friday. The cruise was on the Monday. The appeal judge actually saw more sense and saw the benefit that she would get out of it, so found in his favour. So thankfully, there was a happy ending to this. She did come out and they did go on the cruise. But the point is that had he had a health and welfare lasting power of attorney in place, there'd have been none of that. When he asked for his wife to be released from the care home, they would have had to release her.
Yes.
Such a weighty legal document, it really is. You know, my father-in-law went into hospital at one stage, and my husband, who has two sisters, his younger sister was at the hospital this particular evening, and the doctor came up and said he went in with an infection on his knee, my father-in-law, and they said to my husband's younger sister, you know, we've given Joe antibiotics. His heart's really strong. If anything happens, we're not going to do anything, you know. And she said, oh, right, okay, thinking that's what she had to say. So when she came back and we spoke about it, I said, but that's a bit like, you know, covertly getting permission not to resuscitate. And, you know, you are all attorneys under the health and welfare power of attorney, so you need to discuss together and see what's in your dad's best interest and what he would want, because that's what it's all about. You know, the donor, the person who legally gives their authority to their attorneys, you've got to act in their best interest, you know. But we all knew what he would have wanted. We knew that he would have wanted to be resuscitated, particularly if it gave time for the antibiotics, you know, to heal and take effect on his knee, as it were, you know.
Yeah.
So I said, what you need to do is discuss it, decide what it is your dad would want, and then go and tell the medical profession, look, we're attorneys under the health and welfare power of attorney. This isn't in our dad's best interest. It's not what he'd want. He'd want this. So really such powerful, powerful legal documents. Yeah.
Thank you very much for explaining that, because it seems like the nation is really not knowing that. I don't think most people know about what you just have said. I think it only comes apparent when they find themselves in that particular situation. And I always advise people to make sure that they have provisions in advance of things that will eventually happen. And the same thing is, we've done this with my husband, who is terminally ill, and we safeguarded ourselves with that. So I really, really very much appreciate what you have explained, and I'm sure that our viewers will know exactly now what it means and why it is so important. The other
I think sorry, Maria, I didn't mean to interrupt you, but
okay.
I think the other thing is as well that if it's left too late, or if mental capacity becomes an issue, then it is too late. You can't take lasting powers of attorney out at all. And the only option that's open to you then is to go down the court of protection route with a deputyship. And it's a whole different ball game in a way, because it's not only so much more elongated, but it's so much more expensive.
Exactly.
You know, the application fees are so much more expensive, and it is a bit of a bugbear of mine, really, you know. So I do give incredibly reasonable prices for the lasting powers of attorney for my clients, because if it enables them to get that in place, then that's what I want for them. Because court of protection route is so much more expensive, so much more elongated, but also it's less likely that they would be granted a deputyship on the health and welfare side. It's usually on the property and financial affairs side, because it's quite often interpreted that the medical staff will know best. So therefore, you're restricting yourself of the opportunity to have both the health and welfare and the property and financial affairs lasting powers of attorney by leaving it to the point of going down the court of protection route.
Right.
It's more difficult.
What about how can, for instance, if I would have my parents still alive, and they would have a property, what would be the procedure to secure that property? I've known a number of people who have got elderly relatives, and these relatives live in a house which is signed in the will to the beneficiaries. But what happened if that person living in their own house at the age of, say, 80, 85, they become ill and end up in, say, care home, or even, God forbid, in the hospicium.
Hospice.
The hospice. The properties endangered in being taken over by the authority. Am I correct in thinking that way?
Yeah, you are, because if that's, that's their asset, then it would be utilized towards any fees that were needed. Yeah, because that's the way it could be funded. That's not to say that people will be necessarily booted out of their home or whatever, but it could be the situation that a charge is put on that property. So at the end of the day, when it's sold, then that would then be utilized to pay off for their fees and whatever. So the bottom line is that the children may not then inherit as their parents would have wanted them to, or would inherit what they want them to do. I mean, there's various ways of looking at that, and it depends on the specific situations, really.
Right.
But there's two main ways, I suppose, of looking at it. So one is the type of ownership of the property, the way the property is owned. So you can own your property as a joint tenant, and that's the usual way of owning it.
All right.
If it's, a couple, partner, husband and wife, whatever, and the two of them own the property between them, and they own as joint tenants, they own it 100% each. So if anything happened to one of them, let's say one of them died, then the other one would own 100% by survivorship. Right. Outside of any will, they would own by survivorship because they own it 100% anyway. So one thing that could be done to protect half the value of the property, if you like, which is really a much more economical way of doing things, it's not deprivation of assets from local authority care or whatever, is to just change the way that they own that property. So if they severed the joint tenancy to a tenancy in common, and they owned 50-50 each, both of their names are still on the land registry, on the title deeds, but instead of owning 100% each, then basically they owned, let's say, 50% each. The benefit of that as well is, so let's say before we even think about care fee type scenario or whatever, let's bump me off in this example. I'll be kind to my husband and I'll leave him here and I'll bump me off. Let's say that I predecease my husband and I own as joint tenants with my husband in this example. So I own 100%, he owns 100%. I'm now out of the equation. So he now owns the house 100%. I would have envisaged that my kids would end up with half the house because I deem that half the house is rightly mine. But in this scenario, he's gone off into another relationship. Maybe that other relationship, there's another family or whatever. And so my assets that I would see going on to the kids, my house, has gone off in another way, and my kids may end up with nothing out of that, basically. Now, if I've severed the joint tenancy to a tenants in common, so we own 50-50 each, then my husband can go off and do whatever he wants afterwards. but he's not going to take my half of the property with him, essentially, because my half is going to be bequeathed to my children in my will. And if I wanted to be kind to my husband, I could put a property protection trust in my will, which basically says he's allowed to live in my half of the property, maybe till he no longer needs to, kind of thing. And then my kids can have it then. So they may own my half on first death, but actually they don't get access to it until second death. So he's looked after as well. So there's a benefit in that way. I make sure my assets go to my children, not going off into another relationship that's, you know. And the other side of it is, if I was now alive and I owned as tenants in common, so I own 50% of my property, and I was being assessed to go into a care home, and a local authority come along and assess the value of my property. Let's just say I'm going to give my property a value, just a made up value of £400,000, just for ease. Yeah, that would be nice. Hey. So somebody comes along and they assess me going into a care home, and my assets, if I own as joint tenant, I own 100%, they're going to take the total value of 400,000 into the assessment for care fees. Whereas if I own it as tenants in common, I own half the property. It may be that they take 200,000 into their assessment, you know. So I'm kind of protecting half of the value of my property by just tweaking the way my ownership of the property is with my husband in that example. So that's, you know, a reasonably straightforward way of protecting half of the value of your property. There are other ways of protecting the whole value of your property, which are much more expensive to do. But that half the value, I've just saved £200,000 of protected £200,000 of my property for a you know, quite a nominal fee in comparison. But there are other ways, and there are trusts and things that could be utilized, but legislation has changed and has moved on basically to some extent. So years ago, people would take out family asset protection trusts, and they would overtly say, I'm taking out this trust because I want to mitigate against local authority care fees. And the test used to be the CRAG test, the charging rate assessment would be used as the test. So it would be, is it foreseeable that you're going to go into care? And if it wasn't foreseeable that you were going to go into care in the future or whatever, then you'd pass that test and that was fine. But if it was foreseeable and somebody was on the slippery slope of health, if you like, then they didn't pass that test. So there used to be another regulation that would come in, and it was basically the 6 month and a day rule. So you could have taken a trust out, and as long as you had that trust for 6 months and 1 day, then that would be deemed to have protected it from the light of local authority care. So people would have their relatives either in a home and they'd take them out of a home for 6 months and a day, or they'd have them or put them in respite, because respite didn't count for this equation, or they'd have them privately looked after at home for 6 months a day, and then they'd go back into care home. And that would arguably do the job of protecting the whole of the property. So yeah, they're more expensive, but they did that job. But legislation moved on, and the grey area of that was kind of covered. So the main objective cannot be anymore that you're taking out this trust to protect from my care fees. I'm doing that for myself. There's still the argument that you could take it out to protect your spouse's care fees, because you don't want to aggravate that situation, you know, where they have more, if you like. And people take those trusts out for all kinds of other reasons, you know. It could be that they don't want the beneficiaries to be disadvantaged, if they have special needs and they're on benefits, that kind of stuff. They don't want, if the children were married and were to get divorced, they don't want the inheritance they get to go down that kind of route, to a divorce settlement. They don't want to disadvantage their children with inheritance tax threshold and aggravate that, if they've got their own property and their own assets and whatever, you know. So any trust can survive 125 years. So basically, what's in the trust could be left there until they sort their own inheritance tax issues out, if you like, you know. And so if they're taken up for all those other reasons, their main objective then is not about local authority care fee, but if they are taken out for local authority care fee as the main objective, then the local authority would see that as deprivation of assets. So people have got to be very, very careful really about what their objectives are of taking out these things, you know. Mm-hmm. Yeah, there are ways of mitigating against things because we need to protect our assets, definitely. But certainly the most straightforward and economical way is to, you know, to start off by protecting half the value of the house, definitely. That's...
And can you provide that service for people who would wish to do that?
Yeah, the severance of joint tenancy to tenants in common. Yes, that's done. And as I say, it's a very economical way of looking after half of the value of your property.
Mm-hmm. Now, Corrine, obviously we are under a difficult circumstances now because we cannot go personally to deal with solicitors, with different type of administrative work. So could you explain to our viewers how they can contact you, and obviously how can you serve them under the current circumstances?
Yeah, I mean, some time ago I had a situation where I had to go to the hospital. It was very scary. It really was a very scary situation. And, you know, I remember laying in the bed in the hospital, and it's funny the kind of things that go through your head, isn't it, you know? And one of the things that went through my head was, well, at least I know my documents are in order because of the nature of what I do, you know? So I've got to say that in this COVID situation, I have been really quite frustrated in a way because I know what's going to be going through people's minds. I know that people are going to be worried about having their documents in place and all this. And I also appreciate the fact that they're going to be concerned and frightened to get out there because you can't go out. Yeah. You haven't been able to go out. And also concerned that, you know, they don't want people coming in because you can't allow people to come inside, you know. So there's all that fear that goes on. But really, I suppose my frustration is kind of wanting for people to realize, look, things can still be put in place. They can still be dealt with remotely, you know. I mean, we are on a Zoom meeting now, and that very media could be used for exactly that kind of purpose, you know. So you've still got that visual connection and whatever. And I could do an assessment on you, Maria, on your mental capacity to make sure you've got the mental capacity to take out your lasting powers of attorney, to take out your will and whatever, you know. We can still deal with identity. I can see your original documents. You can send me copies of your original documents, you know, this kind of stuff. The documents can all be prepared. And then essentially what could happen is, because they have to be signed, look, Scotland have changed the legislation, relaxed things recently. So electronic signatures, you know, are valid, but they're not valid in this country. So you've still got to have a wet signature on a hard copy, as it were. You know, documents still do need to be signed. But there's a number of ways around it. They can be posted to clients. So we post documents out to our clients, put post-its everywhere, examples, instructions, can phone up at the time of signing, you know, and guidance and ask questions and whatever. That can be done so that the clients can utilize their neighbors, for example, or if they've got other people in the household who, if it's a will, they can't be a beneficiary, they can't be a spouse of a beneficiary to act as a witness. So if they don't classify in that context, they could act as a witness with their next door neighbors. I mean, for example, our next door neighbor, there's a wall. So basically what we could do is put the document on the wall, for example, and I could sign as testator, and then our neighbours next door could come and act as witnesses. And as long as we've kept 2 meters apart, and I would say we've got our own plastic gloves and our own pens, you know, and we're respecting the social distancing, then we can quite legally have our documents witnessed by them, you know.
Yes.
So that's one method of doing it. If people are local, then I can go around and act as a witness, take a second witness with me, can supervise witnessing and whatever. And even methods like, you know, sort of standing at the front window, as long as it's in the eyesight and I can see the testator sign, or if whoever is the witness can see the testator sign, and they can, with the plastic gloves on, put through the front door or the letterbox and leave it there for the witness to pick up. They can come back to the front window and they can sign in the eyesight of the testator, and the 2 witnesses can sign then and then put it back. So it's all very, very safely done. So, you know, it can all be done without people leaving their homes. And that's the frustrating thing, because I just think I do want to help people. I know I've been there and I know exactly how it feels. And to be worried about things like that at a time like this, when it's so important, I just think once it's done, it just gives that peace of mind. So I really do hope that people can learn to appreciate that and realize, look, don't wait, get the things done, it's important to get them done. You know, I started off by saying to you that I'm the youngest of a family of 9, 4 brothers, 4 sisters, and life wasn't hard. It was very loving, you know, but there wasn't, you know, it was hard, and whatever, we never went short because our parents kind of sorted that and they worked damn hard for it as well. And so I really do appreciate what it's like to work and, you know, and achieve things and whatever. And I've worked hard through all my life, you know, and my kids have. I remember once somebody saying to me, you get your son up to work at 6 o'clock in the morning, don't you? And I said, yeah, that's right. You know, he has a paper round, you know, and if the weather was bad, we would go out and assist him with the paper round and whatever, you know. So it's an ethic there, isn't it, really, that you work.
Yes.
You do want to pass on to your children, and you know, you value that for them, as it were. So yeah, documents to protect those shouldn't be left. They really shouldn't. You should have that peace of mind. And yeah, certainly during COVID time more than ever, they can be achieved. Yeah.
Wonderful. Thank you very much, Corrine. It has been great speaking to you, and I look forward to have another chat with you at some point in the next few weeks. Wonderful.
Great, that's brilliant. You did ask how people could contact me, so I don't know whether it's a way you want to just put the details up of how people, is that the best way?
If you are happy with this, we can put the contact details under the video, so they can click under the video, they can have your website or your email address. If you wish us to,
you can put the phone number, which is 07824631077.
Wonderful, we will do that. And obviously, if we have any questions from our viewers regarding contacting you, we will be glad to pass them on to you.
And the email is info@wtawill.co.uk, and the website is www.wtawill.co.uk. But I'll give you those and you can put them on by all means.
Wonderful. Thank you so much, Corrine. Thank you very much for being with us today, and we look forward to have another video with you very soon.
Lovely, that's great. Thank you very much. I really appreciate it. It's been lovely chatting to you. Thank you.
Thank you. Bye-bye.
Bye.